Federal Flaws. Perceiving the Problem. Segment 2. Illusion. Illusion is most successful when trust defeats truth. Authority figures, like police officers in uniform, generally evoke trust. The amount of trust an authority figure receives depends not on how much trust is deserved, but on how much trust is volunteered away. Trust begins with the self. To trust a police officer with your personal information, you must first trust yourself not to provide incriminating evidence about yourself. All trust is based on a belief that you understand how the world works. When you don't understand how the world truly works, you're living in an illusion. We want to believe the police are there to help us, because we want to believe that we're the good guy and we have a place in society. The truth is a little different. The police can lie. In Fraser v. Cupp, the Supreme Court ruled that the police can lie to obtain a confession. You may be able to trust the actions of a police officer, but you can't trust facts a police officer gives. It may be distressing to learn that the government officials can lie to the public, but that's the general rule. There are exceptions where the government has to tell the truth. The two big exceptions in which the United States government has to tell the truth are the Federal Register and Freedom of Information Act requests. The government doesn't have to tell the whole truth in these places, but what they do say must be true. Of course, the best place for the government to deceive the public is in the courts by using legalese. The American system of government is out of control because the language of our political system is English and the language of our justice system is legalese. It's not possible to fix the justice system using plain English, and it's not possible to fix the political system without a justice system. To fix our system of government, you must learn enough legalese to understand our problems. Here is a short list of the problems that have come from misplaced trust in legalese. The NIST reports, the FEMA reports, and the 9/11 Commission report are hearsay and do not provide an official story of what happened on 9/11. Justice cannot be served because we do not know the truth of what happened. The 10th Amendment to the Constitution for the United States of America destroyed all federal power within the several states of the Union, except most war-making power and the treaty power. The treaty power has been used to circumvent the balance of power between the federal government and the governments of the several states of the Union. Every time the treaty power is used to grant the federal government power, a portion of the sovereignty of the Union must be sold to a foreign nation. The first 10 amendments to the Constitution for the United States of America are the Bill of Rights. In Barron v. Baltimore, the Supreme Court ruled that the Bill of Rights don't apply to the state governments, only to the federal government. It wasn't until the Due Process Clause of the 14th Amendment that the Supreme Court began enforcing some of the rights found in the Bill of Rights against the states of the Union. Even then, only some of the rights are enforced, and only at the discretion of the Supreme Court through a piecemeal process called the Doctrine of Incorporation. This results in a Bill of Rights light. In Dred Scott v. Sanford, the Supreme Court ruled that blacks were not persons in the eyes of the law. This principle was based on the fact that only free, white males who were older than 21 were considered members of the people. This concept was further twisted when the legalese of the 14th Amendment was used to enforce a second class of federal citizenship that was inferior to the class of citizen described in the original Constitution for the United States of America. Since the Bill of Rights doesn't apply to the 14th Amendment citizen, almost all oppressive laws like the Patriot Act are directed at this second-class citizen. This leaves women and minorities without a legitimate claim to the protection of the Bill of Rights, while corporations have been elevated to a level equal to natural persons. The government of the United States maintains two federal court systems. The District Court of the United States is part of the federal judiciary and draws its power directly from the Constitution for the United States of America. The United States District Court is a creation of Congress under Congress's rule-making powers and is not part of the federal judiciary. The District Court of the United States may declare laws unconstitutional by drawing on the constitutional authority of the federal judiciary. The United States District Court may only declare laws unconstitutional if Congress allows it to do so. The distinction between the two courts was made in Balzac v. Puerto Rico. Balzac v. Puerto Rico is one of the insular cases that pointed out that the Constitution doesn't apply in Puerto Rico. This means no one is protected by the Bill of Rights in Puerto Rico. Another insular case was Hooven and Allison Company versus Evatt. In Hooven, the Supreme Court determined that the phrase United States could have three different meanings. One of the meanings of the United States was defined as the territory where the United States is sovereign. Since the United States is not completely sovereign within the several states of the Union, the term within the United States can mean a place like Washington, D.C. and Puerto Rico, but not mean places like the state of New York. This territorial deception can be used to write laws that appear on their face to be unconstitutional, but are in fact extra-constitutional, that is, outside of the Constitution. Laws that violate even the Bill of Rights can be written for places like Puerto Rico and held as valid unless the proper legalese argument is raised in defense. The combination of 14th Amendment citizenship, the territorial deception, and fake federal courts are used to justify and enforce blatantly unconstitutional activities under programs like income tax collection and the Federal Reserve. The foundation of most legal deception in the United States law begins with the first two constitutions. The Constitution for the United States of America, spelled with a capital C, is the treaty that bound the original 13 colonies together in union as the several states of the Union and contains the Bill of Rights. In the Federal Flaws series, when a distinction is vital or necessary, the Constitution for the United States of America, spelled with a capital C, will be referred to as the Fundamental Constitution or the Original Constitution. In the Federal Flaws series, the Constitution for the United States of America, spelled with an uncapitalized C, will be referred to as the Undergovernment Constitution or the Civil Constitution. The Undergovernment Constitution has several differences from the Fundamental Constitution. The biggest difference is that the Undergovernment Constitution was put in place without a Bill of Rights. The Undergovernment Constitution also has several differences in capitalization from the original Constitution. When dealing with the government of the United States, spelled with a capital G, you are dealing with the government established under the Fundamental Constitution. When you are dealing with the government of the United States, spelled with an uncapitalized G, you are dealing with the government established by the Underconstitution. The capitalization of some words like acts, laws, territories, or citizen are terms of art associated with each particular government. The Undergovernment Constitution was first published by Richard Folwell in 1796 in the book The Laws of the United States of America in 3 volumes, pursuant to the law titled An Act for the More General Promulgation of Laws of the United States, found in Statutes at Large, Volume 1, page 443. A Republican form of government recognizes the authority of the people as a whole, but it also recognizes that a special class of person is required to run the government. In a republic, those that govern should be participants of the nation's commerce and well-educated. We might call this privileged class the aristocracy, even if our aristocracy lacked titles of nobility. The men who created these 2 constitutions were from this privileged class. Some of them even wanted a monarchy instead of a republic. These men were following in the footsteps of Plato, demanding that leaders be philosopher kings. These men saw themselves as the brightest, wealthiest, and most successful members of society. They saw themselves as the best people to choose who should govern and how. After decades of legal and political maneuvering, the aristocrats finally succeeded. In the 1870s, at the beginning of the second term of President Grant, the foundational government of the Union was decapitated. The membership of Congress had been tricked into joining the undergovernment. Grant's vice president, Henry Wilson, joined the undergovernment, and Grant himself served as the president of the undergovernment instead of serving a second term as president of the original government. Grant's Secretary of State, Hamilton Fish, became the president of the original government. When Hamilton Fish left office after 4 years, the only thing left to the original government of the United States was the self-appointing bureaucracy of the 6 original cabinet departments of State, Treasury, War, Navy, Post Office, and Interior. These original cabinet offices exercise authority on behalf of the President of the original government, and as such exceed even the authority of the undergovernment Congress or whoever happens to serve as our elected President now. The power of the government of the United States now rests in the hands of self-selected bureaucrats, not elected officials. In the middle of the 20th century, the aristocrats succeeded in decapitating the governments of the states as well. There are people who claim to have occupied the offices of the original state governments, but those claims have yet to be verified. We need a just tax system to eliminate the special interest hold on spending, a sane immigration policy, a system of social justice that prevents poverty, not encourages it, proper oversight of commerce, to rein in the Federal Reserve and gain control of our credit and monetary systems. None of these problems can even be addressed without eliminating the corrupted legal system, establishing equal rights, and validating the correct way our government should operate. In short, we must identify our federal flaws. The Federal Flaws Project is dedicated to building a government that derives its just powers from the consent of the governed and operates with justice and liberty for all. There are solutions, but the principles of freedom require you trust yourself to figure it out.